were a medical student pursuing a medical in the MMC college of Lordship. Karthik and Abhinaya were in relationship and got married according to the Hindu Marriage Act 1955 of Lordship. After their marriage, they lived apart from their family. Due to some issues in Karthik's family, they decided to move to Karthik's home. After moving to Karthik's home, there was a little change in the behavior of Karthik and Lordship. Where the in-laws of Abhinaya wanted Abhinaya to take her marital responsibility and take it to your Lordship. This triple problem moved the Karthik and Abhinaya to the fight frequently, your Lordship. One day, in front of the relatives and the neighbors, Karthik and Abhinaya fight over the quarrel over something, your Lordship, which leads Abhinaya to leave to her parents' home, and there was no contact between Karthik and Abhinaya, your Lordship. After a few days, Karthik texted Abhinaya to meet her, but she refused to meet him, your Lordship. But Karthik went to meet Abhinaya with intoxication, your Lordship. After arguing with Karthik, meanwhile Karthik has lost his. Meanwhile, the Karthik has lost his control over himself, your Lordship, which leads
to have a sexual intercourse without the consent and will of the Abhinaya, your Lordship. Now, Abhinaya has informed the things which have happened the last night to her family, and the family members has made a police complaint to the nearest police station, your Lordship. Now, the trial court has sentenced the Karthik for the 2 years of imprisonment and fine along fine with 35,000, your Lordship. And frequently now the Abhinaya was not satisfied with the trial court's order, your Lordship. She now moving to the High Court of Manavasi for the appeal. The High Court stated that dismissed the appeal of the Abhinaya, your Lordship. Now, along with the V2, Abhinaya have filed a writ petition under to this bench, your Lordship. Next, second case is that when the fire is, your Lordship.
Abhinaya filed a petition or V2 filed a petition?
Your Lordship, Abhinaya along with V2 filed a writ petition under this bench, your Lordship.
Can V2 file a writ petition?
Lordship.
V2 along with this NHU.
Yes,
Can file a writ petition.
Much obliged, your Lordship. Yes, Lordship. The V2 can file a writ petition.
What are the criteria?
File a writ petition.
What are the criteria for filing a writ petition?
Your Lordship, here the V2 is an NGO for women's welfare, your Lordship, concerning women's welfare, concerning all in women.
The question is whether the petition lies by Abhinaya or the NGO or V2. The petition lies by the Abhinaya herself or the NGO or the V2. Because your memorandum says that the petition is filed by the NGO V2. Are you arguing on behalf of the V2 or Abhinaya?
And the council are arguing for Abhinaya along with V2, your Lordship.
Can V2 file a petition?
Along with Abhinaya, the V2 have filed a petition in front of us.
How the NGO can file a petition? Is there any criteria in the law?
Yes, Lordship, under Article 32.
What is the prerequisite for filing a petition? What is the condition or qualities for filing a petition?
What grounds can it be
Your Lordship, when there is a violation in fundamental rights, the writ petitions can be filed
Whose
before.
rights is violated?
Your Lordship,
Whose rights is violated?
Your Lordship, Abhinaya's rights is violating here, Your Lordship.
Person who is violated, whose rights is violated and can have a space for filing a petition. The NGO who is not working with others can file a petition or it can be called in some other way.
Brother is asking what is the locus standi, but what ground is the NGO for coming before this honorable court?
Well, it is filing a self-petition or public interest litigation.
It's fine. It's fine writ petition, Your Lordship. It was mentioned in our fact itself, Your Lordship.
So you have to go to your locus standi. What is the locus standi for the people?
Do you have any precedent like decided which states that NGO or any of the common bodies can approach before the Supreme Court for any violation of fundamental rights of other person?
Much obliged, Your Lordship. Apologies, Your Lordship. There is no case for it.
This one is a before. Is because the council is apparently without knowing that how to approach this one. Not aware of the fact whether an NGO can approach this scope or not, then the president or not. How do you simply approach this scope as to waste the time of people? As you mentioned something in the fact sheet, is there anything in the fact sheet as the NGO filing petition?
You mentioned earlier that the fact sheet, there is a statement that the NGO has approached the Supreme Court, the court has granted permission for that.
In fact sheet, page number 15 paragraph mentioned that opinion with the help of an NGO.
Means business for opinion, the help of NGO filing business, opinion or the NGO?
Opinion have filed the writ petition, Your Lordship.
Your memorandum says it is something a case of veto. Yes, proceed.
Apologies, Your Lordship. While this problem, triple problem is on fire, subsequently there is an cabinet action cabinet action was going to held in the state of provinces, Your Lordship. The party which participating in the election has an election manifesto has to remove the MRE, that is marital rape exception. As a result of the election, the government, the party has formed a government and passed a cabinet resolution for the removal of marital rape exception in section 375 of IPC, Your Lordship. But here we main association filed a writ petition in the High Court of Manawari against the repeal of the section MRE, Your Lordship. The High Court also stated that repeal of MRE, Your Lordship, and now the government has moved to the Supreme Court for an appeal, Your Lordship.
Against who?
Against B2 association. We made association, Your Lordship. The state
Is there any case between the state of Province and the Union of Martha? Is there any direct conflict between the state of Province versus the Union of Martha?
His Lordship, state
Is
of
there any case according to the fact sheet?
second issues deals with state of provinces with the Union of India because the Union.
Whether the Province filed the petition or appealed against the Union of Martha, what is the original case?
Original case is, Your Lordship, Women Association.
Women Association filed a petition.
Yes, Your Lordship.
And they have handled the case. There was an order. Against the order, they go for the Supreme Court. But your memorandum says that it is something about the state of Province versus the Union of Martha. Is there any conflict between the state and the Union?
Yes, Your Lordship, here the first case in High Court, Women Association filed a case. This case first title is Women Association versus State of Provinces, Your Lordship. Now the State of Provinces is going to coming appeal before this court. So
The which clause? Is there any clause where the state can go for the Supreme Court where the order was being satisfied the case? In the second case, on which jurisdiction of this court? Which clause you have approached this court?
for second issue, the council approving under Article 132 of the Indian Constitution, Your Lordship.
Yes, Article 132.
Article 132 of Indian Constitution says that applying jurisdiction of Supreme Court in the appeal from the High Court in a certain cases, Your Lordship.
So here, what is the, is it not such certain thing confined to the, an NGO filed the petition and respond in the government? Where the Union of India, where the Union of Imarta comes to the picture.
While coming to the Supreme Court, Union of that is High Court, representing the High
Is
Court.
anyway Imarta is responsible for the state of province
Yes, Your Lordship.
in Parliament?
Yes, Your Lordship, Imata is responsible for state of provinces, Your Lordship.
In this case,
In the second case, a state of provinces.
so you are supposed to argue for the state government.
Provinces, Your
You
Lordship.
are representing the state.
Yes, Your Lordship.
Okay. Against who?
Against
Who is resisting? Are you opposing the big part of you? Is the Union of Imarta?
Your Lordship, against the High Court order, Your Lordship.
That only.
Who is the respondent? Who is the respondent here? The appellant is state of proviso. Who is the respondent?
Respondent is Union of Imrala is the respondent, Your Lordship.
How do you Union of India come as a respondent?
Because Your Lordship, the state of provinces has a apologies, sir.
Proceeding arguments. Also representing issue number one or issue?
Issue number 1, Your Lordship. Much obliged, Your Lordship. Lordship, my issue is whether the living relationship can be considered as a marriage and a marital rape can be brought under the purview of living relationship, Your Lordship. It is humbly summing up before this bench is that living relationship can be considered as a marriage and a marital rape can be brought under the purview of living relationship, Your Lordship. Before moving to my argument, I like to define what is living relationship, Your Lordship. In a common language, living relationship means is an arrangement between two people decided to live together for an extended period of time or permanently in an emotionally or sexually intimate relationship, Your Lordship. But it's also defined legally in the case of V.K. Sharma, Indra Sharma versus V.K. Sharma. Living relationship has been defined, Your Lordship. A living relationship is called a domestic cohabitation between a major unmarried female and a major male, Your Lordship. Now the council moving to the argument that is living relationship can be considered as a marriage, Your Lordship. Though living relationship is not considered as not recognized by Hindu Marriage Act 1955 or any other statutory provisions, but it is not illegal, Your Lordship. By proving this statement, in the case of D. Velusamy versus D. Pachayamal case law, Your Lordship, I like to give the judgment copy of the in front of the bench, Your Lordship.
Whether you have served the copy to the respondent? Whether you have served this judgment copy to the respondent?
No, Lordship.
Now you direct, without serving copy to the respondent, you directly to the bench. You have to give them opportunity. They have to verify the judgment and they should answer for the judgment.
Apologies, Your Lordship.
And don't you think that culture like live-in relationship would have a negative impact upon the family institution? Don't you think cultures like live-in relationship have a negative impact upon the family institution?
Indeed, Your Lordship. Though it have a negative impact on family institution, but while considering as a living relationship is illegal, but it is violating the Article 21 of the Indian Constitution, Your Lordship. So, comparing to family culture and family institution, there is a right to freedom, right to personal liberty is important, Your Lordship.
See, what is the question of law that was put up in the Velusamy case, and how do you interpret that in your case?
Your Lordship, in this case, actually, Pachayamal climbed the Supreme Court for getting a maintenance from the Velusamy, Your Lordship. While describing that, Velusamy stated that in the Supreme Court, he had already married Lakshmi, a woman Lakshmi.
So in this case, there is a law which can be substantiated with the living relationship. A normal married woman can claim maintenance. So also a living relationship woman can also claim maintenance. Now here, there is a law which states that rape is not in marriage. If that is no, then how can you interpret that in such a manner?
Your Lordship, in the case of Nimishabai Bharatbhai is a state of Gujarat states that, Your Lordship, marital rape can be in the marriage, Your Lordship. That case states that marital rape is an undesirable sexual intercourse by a man with his wife, and where the consent of the wife is not given to any life and is taken for granted, Your Lordship. Thus was the held in our case without clear consent. Sunil had forced herself, Your Lordship.
President Governments.
Much obliged, Your Lordship. While comparing Velusamy Mrs. D. Pachima case law with our case law, the Supreme Court, this bench has described that four conditions. Whether the four condition has fulfilled, then living relationship can be considered as a marriage, Your Lordship. The four conditions are that the couple must hold themselves out to the society as being akin to spouses. The second condition is they must be in the legal age of marriage. And third condition is they must be otherwise qualified to enter into the legal marriage, including being unmarried, Your Lordship. And the foremost last condition is they must have a voluntary cohabitation, Your Lordship. Comparing this case law with our case.
Claim before the court approaching a case. The issue as you are arguing. What is your argument like?
My time is, Your Lordship. The council is trying to prove that living relationship can be considered as a marriage and marital rape can be brought under.
What is the nature of living relationship? How it is differentiated with marriage?
Living relationship is a cohabitation of two people.
Cohabitation of one. Why not they are going to get married? Why they are not referred to in the formalities and ceremonies?
In our fact, it is described Kriya is a
Part of
Yes.
opinion, marriage is an appreciative institution created to the people of
They
humanity.
are considered as an oppressive institutions and they prefer to have a living relationship. But what is the ultimate purpose? Why they are choosing the living relationship between the two people? Kriya and Surya. Financial sharing.
For financial sharing, Lordship, the Kriya and Sunil are in the modern times, so they choose the modern
So
culture.
why the people are going for such practice? What is the ultimate purpose?
Actually, Your Lordship, the peoples who choosing living relationship are not.
Is it in the nature of marriage? Is it in the nature of marriage as you claim?
Yes, Your Lordship.
They expecting
When we are in living relationship, when there is a dispute between the partners, that cannot be. Then when there is a dispute, they need not go to the court for the divorce, Your Lordship. But in marriage, when there is a dispute between the partners, they need to go to the divorce, Your Lordship. In living relationship, the divorce can be avoided, Your Lordship.
they can go in one way. So you already consent, both of them are consented, whatever will happen between the people adjust. Is it your argument?
Much obliged, Your Lordship.
Then she's why you coming for another remedy, the force which made by the husband, the person is supposed to be considered as husband. Get a remedy from his activities. You already adjusted, you are already consented as just themselves. You are coming for another remedy.
Your Lordship, only the The living relationship is a little bit different from marriage. Without the ceremony, the living relationship is conducted, Your Lordship.
You all have the same responsibilities. Is it the argument?
Your Lordship.
Both your husband and wife have the same responsibilities as the marriage have.
It should be.
What is the ordinary husband or wife or spouse? Is there any responsibility over the spouse? Is there anything which is called conjugal expectation?
What are the conditions? Understood.
See, the ultimate question that we are seeking is if it is not a marriage, as the procedure of marriage is not followed, the requisites of marriage are not followed. If it is not a marriage, how come marital rape we apply to?
Lordship, this is a relationship in the nature of marriage, Your Lordship. But before we are asking, what was the nature of marriage? What are the conditions for a valid marriage? If the is revealing, Your Lordship, or that mentioned in the Kachemar, this is the case.
That case is only with respect to male and CRP, 120 days CRPC, not for all of us.
Your Lordship, according to Moot Committee, along with the sixth Law Commission, has stated the report to the Supreme Court that is, living relationship is an extra legal concept that has secured its standard in the society through various rulings passed by the court, Your Lordship. The rulings are one of the case law is Muhammad Ali versus Muhammad Ibrahim Khan, which has held in 1929, Your Lordship. It's stating that Supreme Court stated that long cohabitation between the couple is a sufficient ground to pursue the person as a marriage, Your Lordship. This relation was adopted by the court in various judgments, Your Lordship, and to safeguard the rights of women and children in the living relationship, Your Lordship. Finally, in 2010, it was observed that it's observed by the Supreme Court that the woman and men and women living together without marrying cannot be considered offensive, Your Lordship. There is no law prohibiting living relationship or premarital sex, Your Lordship. Living together constitutes under the right to life and Article 21 of the Constitution, Your Lordship. The court further held, it said that it was the right of individual to choose the type of relationship in which they wanted to be, Your Lordship, which was reported by the Moot Committee along with the sixth Law Commission, Your Lordship, in the Supreme Court, Your Lordship.
Some of your arguments.
Oh. Your Lordship, considering the case of Punjab versus Gurmeet Singh and Nimishab Bhai Bharat versus State of Gujarat, stating that marital rape can be considered, marital rape can be brought under the purview of living relationship. If the bench permits, my counsel will argue. Much obliged, Your Lordship.
May I please the Honorable Supreme Court of Emergent? This is the counsel appearing on the behalf of petitioner, and I will be dealing with the issue 2 and issue 3. At this juncture, I would like to say that all the submission that the counsel will be making will be prejudiced to that of my co-counsel. May I please the Honorable Supreme Court? I seek permission to move on to the second issue, Your Lordship. Much obliged, Your Lordship. Whether the implementation of election manifesto by the government is constitutionally valid. This is the second issue. The third one is whether the whether criminalizing of marital rape is constitutionally valid. This is the third issue. The council seeks permission to move on to the arguments. Much obliged, Your Lordship. It is humbly submitted before the Honorable Court of Immerden that implementation of election manifesto by the government is constitutionally valid and that marital rape exception fail all tests of constitutional validity. The council would like to make the arguments by justifying 3 points, and those are whether the implementation of election manifesto is constitutionally valid. Yes, the implementation of election manifesto is constitutionally valid, and that it is implemented for the benefit of the weaker section of the society and for the welfare.
The implementation has some is any limitation, not only implementation for the activities of the government. The implementation it may be considered to be all right, of course. Is there any limitation, boundary limitation on the activities of the government?
Can you just repeat the question, my lordship?
Implementation, as you promised, you are going to implement. By doing so, is there any boundary limitation, obligation, duty?
Yes, Your Lordship.
What is that?
The duty that is imposed upon the government is given under the principle of state policy, and the limitations are also prevailing. That what all things should be given what all things should be set in under election manifesto or kept in election
The
manifesto.
principle of state policy will give some guidelines.
Yes, Your Lordship.
Can a state take advantage of that principle of state policy? Can do everything what they want to do?
The object of implementation should be for the welfare and the protection of
The
society.
question is there any boundary or constant obligation, constant duty of the state by doing their activities?
Yes, Your Lordship.
What is that?
That is a constant bound and an obligation with certain limitation. For example, the public policy.
Not certain. What are the certain? As you said, certain. What are the things are there to be certain?
Some is one. Certain manifestations or the acts which can be called under section 123 of Representation of People's Act, which comes under the term of corrupt practices. For example, bribery, for want of vote or to want for a need of getting more vote. Some people, some political parties are the one who are going to form the government, purposely put forth certain value or consideration. So that must be limited, and that is certain boundaries where the state government should not step in.
Why? What is the actual petition in this issue? What was the actual petition?
Pleasure, Lordship. The actual petition in this issue is for the implementation of election manifesto that the present government had promised during the election to the people. After forming the government, after the election has been completed, after forming the government, the government passed a cabinet resolution to introduce a bill to remove the MRE, that is marital rape exception, and this was challenged by women association who felt that they are getting affected under section 498A, and then they filed a writ petition in the High Court, and the High Court stayed the implementation of election manifesto, and agreed by this the state of Strovis, which wanted to implement the election manifesto, is approaching the High Court.
On what basis they filed the petition?
The state of Strovis or the women association?
Oh.
The women association. They filed a writ petition.
How a person or association was entitled as to claim against the state without having any obligation on the part of state? You are not mentioning that obligation. Into that obligation part of state.
Can you just repeat the point?
While formulating a policy, while framing a law, whatever it is there any limitation? That's what really that question. Is it meant for the government can do anything? They are not supposed to respect the different parts of the society, different people's rights. Is it not? Is it not anywhere in the Constitution?
The policies must confine with the fundamental rights. It should not derogate any provisions which is provided in the Constitution. And also, while framing a policy or any order or rules, they must confine with the directive principles of state policy as well.
Are they compiled with the directive principles of state policy or something else in the Constitution?
In this fact, Your Lordship, they are,
Not fact as a law.
sorry, much
Are
obliged.
they bound to respect the DPSC or DPSP law? DPSP is something which is in favor of you. You can. But we are asking, why you implementing even the DPSP? Is there anything to limit?
It should not infringe others' fundamental right as well.
That is the point. So the reversal line, the proposal is supposed to be infringing or violating a group of individuals in this society.
Yes, Your Lordship. The contention that we may have took that it is violating.
So in that way, as you taking the promise
Yes, Your Lordship.
to by taking the competence,
Competency to.
you can promise many things in the manifesto. Do you competent to do so?
Yes, Your Lordship. While
Legal competence.
while contesting election, a political party has the right to mention their or declare their.
You can declare, but while you coming to the power, while you formulating or you going to legislate, are you legislatively competent to do so?
Yes, Your Lordship. Under Article 246 of the Constitution, a state government, a parliament or the state legislature is entitled to frame any law or policy.
Now, are you challenging the election manifesto?
Much obliged, Your Lordship. We are not challenging the election manifesto. We are challenging the order that the or the stay that the High Court have made against this election manifesto, implementation of election manifesto. Your Lordship. Seek permission to move on further with arguments.
Okay, any DPSP which will favor to your lawyer standpoint. Is there anything in the Constitution?
Favoring of DPSP.
Much
Much obliged, Your Lordship. Article 38 of the Constitution that says about the state is under an obligation to promote the welfare of the people. That comes under the part under the whole part of DPSP by securing and protecting as effectively a social order in which justice, social and economic, political shall inform be provided to all the institutions. And also Article 46, which lays down promotion for the protection and the improvement of weaker section. So these are the main provision of DPSP based on which the election manifesto has been implemented. Much obliged. So first of all, in the given fact, the political party, namely Democratic Movement of Truth, announced the repeal of marital rape exception, which is given under Section 375 of IPC, Exception 2 of Indian Penal Code. Election manifesto, as it is an evident fact that it refers to a reference document for the public at large, where a political party offers or promises to establish when it comes into power. Here, we are not challenging the election manifesto because election manifesto can be anything. So we are challenging the very nature of election manifesto. That is the implementation of removal of marital rape. So the party during the election, looking into the regretful, shameful, and the distressed situation of women in a larger scale, has promised to implement the removal of MRE. I would like to state a case which was held in the year 2019. Amavasi versus Chief Election Commission, and in this case, certain guidelines were incorporated, like how an election manifesto must be conducted, what are the things a party or a government has to be carried forward. The guidelines are: the election manifesto shall not contain anything repugnant to the ideas and principle enshrined in the Constitution, and the directive principle of state policy enshrined in the Constitution enjoin upon the state to frame various welfare measures. And also, in the interest of the transparency, level playing field and credibility of promises must be established. So these are the following rules. So here the state of Trovis have followed all these rules, and none of the act which is made by the state of Trovis is contradicting these rules. So hence,
What was the intention of the evaluation?
Intention of
What purpose they are trying to move this conclusion?
uh, the state of Trovis have more number of female citizens.
Very obvious acceptance. So the intention was very clear. Yeah, we proceed.
Mr. Lordship, the reason for implementing this in the election manifesto was because the degree of exploitation was much when compared to other things that even the husband
Exploitation is bad.
exploitation within the marital status of husband and wife. So in that case, when a women who have agreed for a heinous crime such as rape, so she must get an apt remedy, and for that purpose, the state of Trovis have come forward with this implementation or election manifesto. So in the case at hand, the election manifesto by the party and its implementation passes all the tests of the code of conduct. And also, as I already mentioned about Article 38 and 46 of of the Constitution, which says of DPSP, so nothing is in contradictory with such provisions.
Can 38 can override Article 14? Is it? Article 38 can be override Article 14.
Article 38 can one provision cannot override the other provision. It should be in accordance. Article 30 is not overriding Article 14. Article 14 is speaking about.
The intention is the
But the contention may be like it's contradicting, but we do accept certain things on our part as well. But still,
the law recognize the spousal sexual orientation in anywhere in the law, any act or any section. Spousal sexual orientation.
yes, yes, sir, Lordship. Sexual orientation is.
The sexual orientation is different with the spousal sexual orientation. Is what I'm saying.
Sexual orientation is different because it differs from one person to another. A person, if he wants to be a man, he can be a man. If he wants to be a woman, that is now the thing has changed.
Whether the law is making any difference or recognize, there are certain things which is called a spousal sexual relationship. You can call it a relationship.
Yes, the law is recognizing spousal sexual violence as well. Yes, it is recognizing.
Next.
It is recognized under the criminal law, that is Indian Penal Code, under section 498A. All the offences which is related to marriage and also domestic protection.
The sexual relationship, the thing is, it's not something about gender. It's something about intercourse, sexual, the conjugal expectation. Conjugal liability, conjugal. Is there anything which has been recognized by law itself? A sexual relationship, the mutual relationship between the husband and wife. The thing is whether the law is supposed to see the relationship between a man and woman, and other say husband and wife. Is both one and the same or different?
The sexual relationship between the law recognizes now all kind of relationship if it is with the consent.
Oh, is it recognized or not?
Yes, Your Lordship, it is.
That's
It is recognized in IPC and it is also recognized in specialized acts such as Domestic Violence Act.
Is there anything in the rape laws?
Council, I think you are not fully understood what my brother judge says.
Your Lordship, can you just
He's asking you about sexual orientation, sexual choice of partners. Does that differ from what is between husband and wife, or is something other than, apart from that, which is recognized under the law?
Sexual relationship within the marriage, sexual relationship outside the marriage. Is there any reference of law? I'm talking about law. Is there any law, any provision which is recognizing somehow the sexual relationship between the husband and wife is somehow
Section 375 of IPC have recognized, and it is separating the sexual relationship with husband and wife and the man and women. Exception 2 speaks only about marital rape. Other provisions or other subclauses speaks about sexual relationship between a man and woman, irrespective of the marital status, whether they husband and wife or not.
Is there anything apart from 375 regarding the sexual
Yes,
orientation
yes.
between husband and wife?
There are other provisions as well. Section 376 B and also C and D 360, 360 B, A, double G.
Yeah.
And all those other sexual intercourses done by other person.
Is there anything in the procedure book?
Procedure section 198B of CRPC. It says it differentiate the sexual intercourse by the
It
marriage.
can be inferred that there are many areas in the IPC, CRPC, and somehow recognizing the spousal relationships, spousal sexual relationships. Now, what is the intention? The government has to disturb the spousal relationship.
The intention of the government is not to disturb or the spousal relationship. The very intention is to get a remedy for the offense that is committed. So here the remedy for the women or the wives who have been under the canopy of marital rape, but there is no consent at all. And
With respect to the consent,
yes, Lord.
with respect to the rape and marital rape, the consent is there any difference between the person which is not known to the offender or the spouse? Consent is a consent which has been gained at the time of the activity, or is there any liability or has to be consent?
Speaking, I would like to point another term here with the consent, that is will. Will is something which is broader, and consent is something which is shrunk down. Will is constant, whereas consent may change from time to time.
So is there any difference between the relationship as a wife, as a woman, with respect to the consent for rape? Is there any difference?
Yes, Your Lordship.
What's the difference?
Under rape, there is no consent first of all, and in marital rape also there is no consent. So only because there is no consent, that is the problem is arising. If there is consent and will, there will be no.
Criminal law, as declaring this offense, we will not expect it. There is no any liability or duty to be consent, to be giving consent. But is that not in the case of the spousal relationship? There is a duty of consent, has to be consent, but occasionally differ. That the bench will decide. But is there any space for has to be considered?
Case of marital relationship, it is said that once married, consent is irrevocable, and at the time of marriage, consent is given. But that is what we are denying now here. That consent at the time of marriage.
The question is whether the Article 14, as you described in the women and wife, so ordinary women, or as a wife, counseling,
What would have been the intention of this, the drafters of this law, while invoking this session?
Yes, Lordship. The very crux or the focus by framing this exception to section 375 is to distinguish the marital sexual intercourse and the other courses. That was the main object. In order to differentiate the status of husband and wife from other people, this was.
What I understand is that they would have inferred that husband and wife, the relation between them, any intercourse would not amount to rape.
Yes, Lordship.
Now, what is the forcing or coupling situation that makes this particular intercourse between husband and wife as rape?
The main thing that's disturbing here is the individual freedom or the liberty. While earlier women were under the submission of husband, so though the husband was abusive, there was no other way she have to go in. But now as the time changes, everybody is thinking a lot and they have their own freedom of thought and expression where now it's
values are still remain same. The things may change. Values not.
Values in the sense the moral, Your Lordship.
Maybe.
Morals is also changing. Moral does not change, but law is changing according to the satisfaction of people.
If there is a difference, as you are doing that, there is a different approach between the married women and unmarried women with respect to the rape law. What is the intellectual differential between the two groups?
The intellectual differential between both of them is the object. That is a rational nexus.
Let me just give a small interpretation. You have this parental authority and quasi-parental authority. So a father or mother has a right to give a reasonable weight to his children. And if anybody other than the parents give, that will come out to animals. Same here. Anybody other than husband or wife has a forceful, compulsive, a forceful relation that would amount to rape. But inside a family, with their husband and wife, how can it be a rape? That is the question that the court is concerned. Maybe assault and physical harassment, that is okay, but rape, why it should be a rape?
The reason it should be considered as rape is because of the non-desiring context. The undesirable sexual intercourse is where the problem lies. And women are now seeking for their individual liberty and freedom, where they don't want to be under someone's control. And the time has changed. So for that purpose,
See, in that case, even that can be ground for divorce. Why it should be mentioned as rape? Have you made any surveys, any reports that you are having, any foreign court judgments, any foreign surveys, articles, seminars, any reports, something like that? So that important get.
no, apologies, Lordship, I don't have any reports, but still I would like to justify the point that I'm saying. Rape is, though the reason is the marriage status is only differentiating. Apart from that, everything is same. The consent is not there, and there is and that too, whenever the husband is willing, they can have sexual intercourse. The will of wife is not at all considered. So in that case, what the wife is intending that one have to that she have to the right and freedom to say no when a person or a husband is coming towards for sexual intercourse. So she's trying to find a very remedy of rape for this marital rape and not to distinguish only because they're getting into the marital relationship. So that is.
When your country's personal laws are so diversified, why have you chosen marital rape? Don't you have any alternative remedy?
Yes, Lordship. There are alternative remedies. Even in the IPC, we have the offense related to marriage, and we have other remedies as well. But the punishment.
Can you state those alternative remedies and why you have ignored those and you have chosen marital rape here?
Yes, Lordship. 376 B, that is, it provides for sexual intercourse by husband when they are separated. And then also we have 498A, which says of cruelty. So marital rape can also be, it's a sexual assault as well, so it can come. So we have alternate remedy. But the punishment in these provisions are not equal to that of the rape. Rape is a heinous crime which is equal to murder. Murder is just killing of a man, killing of body, but rape is killing of soul. So in such case, the punishment, which is the problem where people are seeking for a better remedy than what the other alternate remedies are laid down in the statute.
You want more punishment, so you have chosen marital rape.
Much obliged, Lordship. Not just more punishment, correct punishment, apt punishment. That's what you're seeking.
Like the marital rape, the implementation is very difficult because this marital rape exception, section 114A will not apply for this. Already Supreme Court several times insisted that 114A will not apply for this. Then how can the prosecution prove the marital rape? So it's also a big question.
This can be proved by the circumstantial evidence, by the way a woman is getting affected, because not all women go and complain for marital rape. There are women who are accepting, there are women who are acknowledging that, okay, we are into marriage and we should not do. But there are some women who are exploited a lot, more than a degree that is to be done. In that case, if a woman is coming and filing an FIR or lodging complaint against the women, So that must be taken into consideration because that extent of women is affected.
There is a possibility of more number of false complaints raised.
Yes, Your Lordship. There is possible of more complaints, but compared to the false
complaint.
Compared to the false complaint, the amount of women getting affected is more. So for considering this false or misuse of law, we should not ignore the larger section which is getting affected.
If the woman want to harass the husband means then how the wife will affect her. Husband only affected.
If a woman is harassing her husband, there is also the law also protects the man as well. Where now recently in 172nd law report, the term rape has been changed to sexual assault, which gives us a idea that there are gender neutral status than the gender specifics. Even men can file for sexual harassment or any domestic violence.
So is it a bonus for the men?
No, Your Lordship,
Petition
nothing.
against you is the men's association, just like that.
Yes, Lordship. I'm not fully supporting women or I'm not fully supporting men. So I'm trying to pick up balanced thing. Though there are misuse of law, women are also affecting, torturing men. That is prevailing. I'm not denying the fact.
You're afraid of the misuse, you?
Yes, Lordship. Actually, afraid of misuse should be a
Then
concern.
it is criminalized. How do you conduct investigation now?
Investigation have to be
Claim was made by your wife under 375. I'm asking you already. You presume that it is criminalized.
Yes,
There
Lordship.
was a complaint. How many can be investigated by investigation officer?
The burden of proof is upon the wife to prove that whether the
As the wife has to prove.
yes, Lordship. In many cases, like
Being a compliant physician or is that anything to conduct an investigation? The closed rooms. When they can go, when they can find is there any witness evidence. Nothing can be attracted to the particular scenario.
yes, Your Lordship.
As you stated, it is you are afraid. It just is there is a space for abuse of this permission if it is criminalized.
Yes, Your Lordship. But exploitation now, because of marital exception, will be reduced. So what we contend is at least to reduce the exploitation. Maybe if this MRE is criminalized, men will get a fear of.
Some of your arguments.
Much obliged, Your Lordship. The council seeks permission to move on with the prayer, Your Lordship. Whereupon the light of the issues raised, arguments advanced and authority cited, may this honorable court please to declare that live-in relationship is considered as marriage and marital rape can be brought under the purview of live-in relationship, and declare that the implementation of election manifesto is constitutionally valid and the removal of MRE is also constitutionally valid, and to declare that the criminalization of marital rape is constitutionally valid. And as for the act of the kindness, the council on the behalf of petitioner shall duty bond forever humbly pray. Much obliged, Your Lordship.
The council seeks permission. The council seeks permission to approach the terrace. Much more.
Good evening to the Honorable Bench. If it may please, the Council recognize the gracious presence of your Ladyship. However, for the convenience of the proceedings, the Council seeks permission to address the bench as your Lordship. Much obliged, your Lordship. The Council is appearing before this Honorable Court in the matter of petitioners Abhinaya, State of Trovis, and Kriya versus Union of Imada and Women Association on behalf of the respondent in response to the petition filed under Article 32, 136 and 139 capital A of Constitution of Imada. The Council seeks permission to state the facts.
appearing on behalf of whom? You are appearing on behalf of whom?
Respondent, Union of Imata Women Association.
Okay.
Here the petitioner number 1, Abhinaya, the wife of Karthik, was living with her in-laws, and due to certain family issues, she left that place and moved to her parents' place. On a particular day, Karthik, while intoxicated, went to her parents' place and forced himself on her. The very next day, Abhinaya and her parents filed a complaint for committing rape, and FIR was filed under the section 376. 498 capital A and 354 capital A of IPC. On 28 May 2021, the trial court in its ruling held that the Karthik is not found guilty of rape but guilty of other 2 offences and committed to and sentenced to 2 years imprisonment and a fine of rupees 25,000. Abhinaya approached the High Court of Manavai, where it got dismissed, stating that the law of land doesn't recognize marital rape. Agreed by this, Abhinaya, with the help of an NGO called V2, has approached this Honorable Supreme Court under a writ petition numbered 1234 of 2021, seeking justice. Yes, Your Lordship.
V2 has filed the petition.
With the help of an NGO, Abhinaya filed the writ petition, seeking justice and to make marital rape an offence. This matter in state of province got a media attention, and a regional party called Democratic Movement of Province has amounted in their election manifesto to remove the marital rape exception. And they got a majority in the subsequent election and they formed the government. The government has introduced the cabinet resolution to introduce a bill to remove the marital rape exception. We made an association of men that affected by the section 498 capital A of IPC filed a writ petition in Manavai High Court. The High Court stayed the decision of the government for that removal, and the government appealed to the division bench of that Manavai High Court, where the division was divided, and the judges granted specially to the Honorable Supreme Court. Now here the state of province as petitioner number 2 has approached this Honorable Supreme Court to implement the election manifesto. Moving on to petitioner number 3, Kriya and Sunil were in a living relationship, as he was of the opinion that marriage is an oppressive institution. For 5 years, in 2020, due to global pandemic, Sunil lost his job and their marriage went to downfall. And Kriya became close with her team leader, Praveen. This related to bitter quarrels between them, and it resulted in him hitting her and forced himself on her, and it led to bodily injuries. Kriya went to file a petition. Kriya went to file a complaint for committing rape and committing marital rape, but the police refused to file the FIR, stating that there is no ground for marriage, there is no evidence for marriage between them. She filed a writ petition before this Honorable Supreme Court, stating that her complaint must be taken up as a marital rape and relief must be granted. The council seeks permission to state the issues, Your Lordship. Much obliged, Your Lordship. Your Lordship, in this case, there are 3 main issues. First one, whether the living relationship can be considered as a marriage and can marital rape be brought under the purview of living relationship. Second, whether the implementation of election manifesto by a government is constitutionally valid, and whether the criminalization of marital rape is constitutionally valid. The council will be dealing with the first issue for 22 minutes, and the co-council will be dealing with the second and third issue for 23 minutes, and respectfully reserving 5 minutes for surrebuttal. Much obliged, Your Lordship. Your Lordship, the council seeks permission to proceed to the arguments and points. Much obliged, Your Lordship. On behalf of the first issue is whether living relationship can be considered as a marriage and can marital rape be brought under the purview of living relationship. On behalf of the respondent, would like to argue by saying that living relationship cannot be considered as marriage and marital rape cannot be brought under the purview of living relationship, which council would establish on 3 grounds. Firstly, meaning of living relationship does not come under the meaning of marriage. Secondly, a relationship which is in the nature of marriage does not constitute marriage. Thirdly, a non-consensual sexual intercourse by a partner in living relationship does not constitute marital rape. Moving on to the argument, Imarda, a secular country with a number of religion and having a rich cultural family heritage that considers marriage as a sacred union of two personalities for the protection, maintenance, and procreation by practicing self-restraint, reciprocal cooperation, and self-service. People of Imaga are solemnizing their marriage either with their religious rituals and ceremonies that are mostly codified by the personal statutory laws, like Hindu Marriage Act of 1955, Parsis Marriage and Divorce Act of 1936, and the laws like Special Marriage Act of 1954, and for the people irrespective of religion. Even though the Section 5 of the Hindu Marriage Act of 1955 states the conditions for legality of marriage, none of these personal codified laws, statutory laws, define what is marriage. But on a general term, on a legal ground, marriage is a legal contract and a civil right between a man and a woman, voluntarily undertaken by both the parties in a formal way. And once concluded, they gave the status of wife and husband, which is recognized.
Also, there is no definition of the statement. Is there any law which you prescribe such a condition supposed to be fulfilled at the time of marriage?
Pardon your lordship.
Is there any condition or prerequisites of a marriage? But is complied, we can consider the marriage as happened.
Yes, your lordship. Even the rituals, like walking 7 steps around the fire, it constitutes a marriage. There are a lot of customary practices in solemnizing a marriage, and the section
This is
7 of
only with
Catholic.
respect to Hindus.
Yes, your lordship. And
Only with respect to Hindus.
yes, your lordship. And I would like to add, the section 7 capital E of Hindu Marriage Act also it's to self-respect marriage, where the solemnization is just by the taking an oath. This
Apart from the statutory rights, is there anything the Constitution confer an individual they can lead a life of their own way, as they want to have?
lordship, I couldn't hear you.
Is the Constitution confer any right of an individual to choose their way of life, including the system of marriage and the way of marriage?
Yes, your lordship, Article 21 guarantees that. Can I proceed with the
Yes,
lordship? Much obliged, your lordship. Which is recognized under Article 21 of the American Constitution and also by the Article 16 Class 1 of Universal Declaration of Human Rights, which states that men and women of full age without any limitation, that is race, nationality or religion, have the right to marry and found a family, which is in American society, this marriage which is more legally and socially accepted concept of relationship. With this kind, moving on to the relationship, the concept of relationship is just an association of two people cohabiting outside marriage. It is an association between an unmarried man and an unmarried woman. Even though the Supreme Court in Kushbu versus Kanyama and others case in 2010 has observed that live-in relationship comes under the ambit of right to life and personal liberty, it does not proceed by any codified laws in the Imaga. On a literal interpretation with these arguments.
Council, further, recently, Supreme Court in expresses Institute of Delhi stated that with respect to medical termination of pregnancy at Rule 3DA, marital rape exception, the living relationship also comes within this scope for abortion. So, the Supreme Court recognizes.
Yes, your lordship. I like to add to that. It states that they can consider rape as a marital rape and consider the living relationship only for the purpose of termination of pregnancy. I would like to add that. Can I continue with my proceedings, your lordship? Much more to do.
What about the other ways where the living relationship was already considered by many of the high courts?
Your lordship, for the protection of women and children, there are many under many legislation. For example, protection of women from domestic violence, the two includes the term in relationship in the nature of marriage, which also includes the living relationship. On literal interpretation of this question, that the meaning of living relationship does not comes under the meaning of marriage. Both have, as the both have different social, psychological, ideological, and emotional bearings. Moving on to my second ground, live-in relationship is in the absence of any specific legislations. The Supreme Court issued guidelines in Indra Sharma versus PKV Sharma case in 2013, regulating such relationship by laying down some criteria, stating that it only includes unmarried women and unmarried men, and also with like a legal, there has to be a legal age, and there has to be significant and reasonable period of.
Is there any non-compliance with the particular case? The Verma case, the guidelines, in the case in hand, is there non-compliance?
Sorry.
The condition which was cited in the case of you stated,
Yes, Your Lordship.
in the present case, is there any non-compliance as to not denying to relax living relationship as not being?
Could you rephrase your question?
Is there any non-compliance? There are some guidelines, the case you stated,
Yes, sir.
there are some guidelines. In the present case, between the Kriya and Sunil, is there anything which was not being complied with the guidelines which was stated by the Supreme?
There is nothing like that, Your Lordship. But in order to state like,
What is the observation of the court in that particular case? Is there is the guidelines, but has been complied, they can consider the marriage, the nature of marriage. So here the claim was the same.
in that, Your Lordship, in that case, they recognized the living relationship and laid down some criteria, but they didn't consider this as a marriage. Maybe they quoted the
So
term.
there is no need to consider a relationship between the nature of marriage. They are asking the benefits or protection of the marriage. They are not asking to consider, because it is not marriage as in the ceremonies has not been performed. But the claim is the protection, privileges, immunities, which is available to the party of the marriage, which may be equally available to the party, those who are in the nature of relationship, nature of marriage.
Yes, Your Lordship.
What is the reason to deny it?
Yes, Your Lordship, the judiciary has recognized the partners, female partners in living relationship as a, and they have recognized their vulnerability too. But here the issue lies is whether the living relationship can be considered as a marriage, and my arguments are supporting them. Can I proceed with the arguments, Your Lordship? Much more, Your Lordship. And also, if in this case it's stated some other criteria like there has to be a legal age and a significant and reasonable period of relationship and a voluntary cohabitation in order to consider it as a relationship in the nature of marriage. Whereas in the recent case, Gulzuar Kumari versus the state of Punjab and Kushman versus the state of Haryana, the Punjab and Haryana High Court dismissed every protection filed by a young living couple where the girl is 18 years old and the boy is 21 years old, and claimed protection of life and liberty from the relatives of
Also, just directly say what are the reasons or the criteria which has not been complied as not to recognize the living in relationship not to be considered as a marriage. Is that in that answer? Why you are not ready to recognize?
There is no legal grounds to not consider it as a marriage. There is a social and moral.
There are some verdict which is considered as marriage. The benefit, as I just told you, the benefits are immunities. So here, what is the need of considering something which was not actually, but we are legally recognizing this as a marriage. So it is a legal recognition. What is the purpose of such kind of recognition?
Even in the recent case, there was a split verdict on this decision, stating one of the judges stating that this would destroy the social institution of our society, and even that is absorbed in
What
this.
is the judgment? State the judgment which you are referring to.
The council is unable to produce it.
Not unable, how can you quote before the court?
I would like to just go to ultimately talk to
The judge is asking you very particular question. As why are we not able ready to recognize when other previous or senior judges are recognized as a right to court, and now you see you are not ready to recognize it. Is there a specific ground which you would like to state that on these grounds living relationship should not be considered as a marriage? I am asking, we want equal to marital.
It has to be this side or that side. What is the purpose? Why we are discussing these all the things?
constitution of the society. Like it reflects the society. Sunil and Priya are just a face of the society. Now we are dealing with the majority of the countries. Can I proceed with my arguments?
Society is very diversified. So by society, we mean Tamil Nadu is individual society. We have our own cultures. And when you go to metropolitan cities, IT industries, their culture is totally different. Their society is different. Their way of approach towards love life is different. Marital life is different. So that cannot be one single code. So that is the reason the court has given our general guidelines in what is live relationship and how come that live relation can be equated to the marital life.
Himalayan society being conservative in high cultural heritage, the Himalayan judiciary and legislature also tries to protect that moral values of the society.
Issue is concerned with the two things, whether as we are going to recognize the living relationship and this has to be for the marital. So the context is the rape. So in that particular context, we are supposed to close the argument.
I'll
That's
proceed.
the first issue itself.
Yes, Your Lordship. I'll proceed with that. In the last court judgment, in the Punjab and Haryana High Court dismissed a plea protection filed by a young living couple that the girl is 18 years and the boy is 21 years and claimed protection of life and liberty from the relatives of the girl. The bench headed by the Justice Keshra Khan observed that the protection given to a runaway couple in living relationship who claimed to be in a living relationship would disrupt the social fabric of the society. Hence, the living relationship, which is considered or legally regulated.
The petitioners somehow want to claim, even they don't want to get into the ceremony of marriage. But is that the people are not ready to get the following the ceremonies? Doesn't mean that they are completely losing all the right to liabilities. They have been living for 5 years of cohabitation. There is a shared divorce. So she wants to recognize if they somehow they are in the marital relationship. It's a reason why they are very claiming it as a marital plea. Recognizing the relationship first, that has to be considered as a marital plea. The claiming in such a way, how you define it?
The council recognized the vulnerability of being partners in living relationship. However, the Himalayan judiciary in many cases has recognized many vulnerabilities like domestic violences, maintenance, property rights for the people in such relationship. Whereas here the question is about the marital.
Here, this bodily integrity. This is not something about property or compensation. So as the 125 CRPC was extended, domestic violence is extended. This is someone's bodily integrity. She has, as being in the part of the living relationship, doesn't lose any such kind of right. Still, she has the right. She has to decide the bodily integrity of her wife, the partner in the living relationship. Have you denied?
No, Your Lordship, I'm not denying the right to.
If you are not recognizing means it is denied. That is the petition was voted.
We can't recognize the non-sexual intercourse in a living relationship as a rape. It does not have to be under a marital rape. That's the argument here we are putting forward.
She had all the chances to do away rape itself.
Yes, Your Honor.
But that is a powerful difference between rape and marital rape. Rape is something, the sexual relationship outside the family of marriage. But the marital rape, this is something about within the marriage. There is a very wide difference.
Yes, Your Lordship.
The petitioner somehow want to recognize the right to dignity within the marital relationship. He want to protect herself.
Yes, Your Lordship.
Not simply ignore a lady who simply goes with the living relationship.
Yes, Your Lordship. But your question can contradicting with the facts of the case. That it says.
No, the fact is simply stating that they made a petition, but the police, your authorities has refused. The reason, the fact itself has stated that there is no evidence of marriage. It seems if there is any space for the marriage, because we have another petition in the same court, so that we have integrated. We have to test the question of the constitutional of the marital rape. So here the petitioner, right, as the court is understood, she wants to recognize the relationship between the Sunita and the Priya, somehow a valid and a very dignified relationship. In that, she wants to recognize. If once the 375 is criminalized, it is something about within the relationship of marriage. There is a violation. There is, since they are being a part of this marital relationship, it doesn't mean that they lose all the right. Still, they have space.
Yes, Your Lordship.
That is the petitioner claim. You should not simply blame the petitioner.
Your Lordship, I apologize for I'm not blaming the petitioner. I'm just stating that the facts of the case where Kriya, before getting into a relationship, was to have a strong opinion that she considers this marriage as an oppressive institution. And they both were mutually get voluntarily agreed to get into a live-in relationship. And suddenly, after 5 years, due to some issues between them, she comes and claims it as under a marital rape, which cannot be, which can I take a moment, Your Lordship? Can I proceed with your arguments, Lordship? Much obliged, Your Lordship. The division was the bench headed by Justice Hemant Gupta and Vikram Nath in Ansar Mohammed versus State of Rajasthan 2022 case. The apex court noted that women who have been willingly living with a man and is in the relationship with the same person cannot eventually file a rape case if the relationship has turned so. They mentioned that the relationship has been going very well and suddenly there was a downfall only because there is a sore moment. She cannot come and file a petition, claim a complaint claiming to be a marital rape.
In this scenario, do you find any difference between a married couple and this Kriya? So this court is going to clarify another issues also, whether the 375 has to be the marital rape has to be criminalized or not. Once it is criminalized, the bench has presumed that there is a criminalization. So what is the remedy for the Kriya? That is the question.
In this,
If it is a marital rape also, the same thing. Do you find any difference between the Kriya and the Abhinaya?
Yes, Your Lordship. Whereas in Abhinaya's case, their marriage has been registered and solemnized, whereas here they are in a living relationship, which is not.
The thing, if it has not been registered, is that giving a biased view. Abhinaya getting a remedy, not for this Kriya.
Because this Indian legislature has
Claim the recognition of living relationship. The issues is very connected with the two people.
Yes, Your Lordship, but the issue here is they were in a living relationship which is not till the moment of this proceedings. They're not recognized in any legislative. There is no specified law for it.
There is no any legislation, legislative recognition of the living relationship. There are some legislation which is deliberately mentioned that there is a nature of marriage.
But it does not recognize the.
The council would like to add on.
Yes,
See,
Your Lordship.
not all 100% marriages are registered in the registrar's office. There are marriages which happen before people, and there is some Sirdatta Tirumana which is happening before people. They are all living happily. Now, my question is if that is also okay, living relationship is one form of solemnizing a marriage. That also should be taken into consideration in the purview of marriage. You cannot leave it that way.
This kind of, Your Lordship, but in this kind of relationship, when the people find it, they don't want to continue this relationship more, they lose their obligations too. Most of the time, the men lose their obligations too. So if we consider, like if we recognize this as a marriage and we consider the marital rape under this purview, it would lead to the destruction of many institutions, which it would shape the moral values of the society, Your Lordship. I would like to, the council seeks permission to conclude my arguments. Your Lordship, the living relationship can be it can evolve in this new modernized society, but immigrant society still renowned for its high cultural heritage. High cultural heritage, we cannot consider this as a living relationship, as a marriage. That's all, my co-counsel will proceed with the second and third issues.
The council seeks permission to move on the The council seek permission to move on the issues. Number 2, whether the implementation of election manifestos by the government is constitutionally valid. In this behalf, we have submitted Honorable Supreme Court of Imarta. The issue number 2 is not the implementation of election manifesto by the government is not constitutionally valid because the definition of election manifestos is clearly mentioned in the Part 8 of the Model Code of Conduct given by the Supreme Court previous case laws to direct the Election Commission of India. It is a statutory body to given the guidelines, but it does not given any other implementation of election manifestos mentioned there.
Council giving a promise itself, they are going to implement. There is no need another rule. There are certain things to implement. And just promising means what? You want to implement it.
This is implied promise, my lordship.
Sorry?
Political party given the implied promise after it's come to power.
No, the council stated that there is no law of the implementation of the election manifesto. The election manifesto itself is an integral part of the implementation and they come into power. Nothing more than that.
Much obliged, your lordship. In this, I will state.
Also, this is a strange petition to seek this kind of remedy because earlier this court faced the persons they are wanting to implement the electoral promise. So such kind of petitions we have faced. But this is a strange where you are against the implementation of electoral promise.
Much obliged, your lordship. I will address the question of lordship. Thank you, my lordship. In this behalf, the election manifestos is not equivalent to the electoral promise because
Is there any law to differentiate the electoral promise and election manifesto?
in the behalf, please given the issues and guidelines given by the Election Commission of India dated 16th March. Page number 1, all parties and candidates shall avoid scrupulously all activities which are corrupt practices and offences under the law. So, in this behalf, Article 13 of the Immortal Constitution will affect
Whether guidelines differentiate electoral promise
The answer was not there in the document.
Is there any differences mentioned here? You stated just now, you stated that there is a difference. Is there any differences here?
What is the difference between election manifesto and election promise?
Election manifestos is given the promise in front of the electorate before the announcement of the election. Before the announcement of the election. The election implementation of manifesto is questioned before the Honorable Supreme Court. In the matter of election manifestos, implementation is completely violating the fundamental rights of Article 14 because it's against
The council is supposed to know if there is a policy decision of the government to do certain thing. The court has to go fine. You just defend it is not a policy decision of the government.
much obliged, lordship. The Article 13 subclass 2 given the clear-cut evidence. The state shall not make any law which takes away or abridges the rights conferred by this part.
The political parties, they need not worry about the violation of fundamental rights. If they come to power and they enact laws, then the law can be going to challenge before the court. So it is after they come to power alone, the question of violation will come. So this is electoral promise is given by a political party. So where is the question of violation?
In this election manifesto comes under the removal of marital rape exceptions.
Whether your contention against the election manifesto or the decision of the government.
Both.
Whether the election manifesto is the law in the meaning of the Constitution.
Election manifestos is constitutionally not valid.
No, you not question.
Election manifesto need not satisfy the constitution. We can say anything. Is there any restriction?
Yes, my lordship.
Where is the restriction?
I will address in previous case laws, a Subramanian Balaji versus state of government of Tamil Nadu and others, had examined the issue and inter alia directed the election commission for guidelines. There is no enactment before the provision of this case. So we are the guardian of the Indian Constitution as well as the support of the fundamental rights of all the welfare of the people. So ruling government, it's not comes under the power. It's do anything without the interference of the court.
So I think the court has to refine. The court will not interfere each and every activities of the government. They have certain their own space.
But it's violating the fundamental rights.
Just establish how it is violating your fundamental right.
Much obliged, your lordship. The Supreme Court definition on corrupt practices under these election manifestos for some addressing.
Also, do you mean that giving an assurance that we are going to remove the exception clause 2075 as a corrupt practice?
Removal of marital rape exception is not constitutionally valid.
Why? There are affected women are there in the state in a huge number. So the party is very much concerned about the ladies, women. So that they have made an assurance, they made a promise. They become to power, they are doing. What is the problem?
Which right is violated?
This Article 14 and Article 21 also violated.
Article 15 class 3 safeguards the women's right. But there is a controversy between Article 14 and 15 class 3. Which one is prevalent?
Much obliged, your lordship. Another special legislative laws to cover this rape because to protect the women rights.
Can you challenge any cabinet resolution, first of all?
This cabinet resolution in to introduce a bill to infringe the fundamental right, the court can interfere.
Your reputation before the High Court is premature. You cannot file such kind of reputation before the High Court. Because how can you challenge a cabinet resolution? It has to become a bill, and after that it has to introduce before the legislature, and the legislature have to vote for this. Then after getting assent of the governor and the president, then alone it will become a law. Then after that alone you can challenge. So it is highly premature.
Much obliged, your lordship. The president and the governor's assents may not interfere or may not questionable under the emergent constitution. But in this regard, the cabinet resolution violating the men's, it's considered by us.
Precedents. There is a restriction, the cabinet resolution itself. But is there any precedent where the cabinet resolution was passed?
Is there any Supreme Court judgment with respect to their passing the cabinet resolution?
Not aware of this, lordship, but address the Supreme Court for corrupt practices of.
How you challenge the cabinet resolution without supporting any decision? How can you challenge?
I quoted in the previous Supreme Court judgment.
There are only you can file such kind of petition. Otherwise, it is not maintainable. High Court entertaining the petition is wrong. High Court wrongly entertained the petition. Granted stay is also absurd.
The validity of Election Amendment Act 1975, given the clear-cut definitions based on the language of Article 71, subclass 1 of the Constitution, all doubts and disputes arising out of or connection with the election of President or Vice President shall be inquired into and decided by the Supreme Court, whose decision is final.
Council, as we presume that you can entitled to implement your, as you're defending that the government, how it is valid you are coming to the other part.
The women associations is one of the association for the parties.
Women association or a men association?
Men association. We men against the V2 and Abhinaya and some of others and the state of Travis. Apart from this, we men association is violating the martial rape exceptions. Marital rape an exception. The Imarta is one of the 32 countries where marital rape is an exception, but the divisional bench of Delhi High Court in RIT Foundation versus the Union of India. This is a 2015 case. The split decision.
So you said it violates Article 14?
Yes, of course. Article 14 as well as the Article 21, right to privacy and right to life. Because the principles of our Supreme Court of Emerta.
Is it not under reasonable classification?
Does the article allow any discrimination?
Yes.
Okay.
There are Article 14 given the two test validity. First is rational excess, another one is intelligent differential. But in this case laws, in this fact, before the Supreme Court of Honorable Emerta, the judges of division disagreed the fact.
The test in your case. What about the differential weight?
The criminalization of marital rape.
Also, this statement is something about differential and rational. What are the differential? You just made out in this case against the goal of the government.
Section 114, capital A, the presumption of the government or presumption of the case is only for the woman. For before the booking the rape case or any other sexual assault. But in this rape petition, we have to clearly address
the status of men and women, or the husband and wife in the family is equal in all the domain, all the cases value.
Both are equal, but not this rights is independent. Right of privacy, right of body self-determination is different. Yeah, both have human rights, not violating the human rights also. Both have the rights. The important meaning of the casual relationship or marriage is not only the intercourse of the sex, body. It's in between. He can cohabitate with the love and affection also. Then the marriage will be continued.
The situation is stating. Why the domestic violence against women are in the following?
Because so many statutes of special statutes given the remedies available only for the woman, but
this is also in the same line. The movement, the reform, is making the women somehow.
the marital rape exception is the 375 of section 375 of Emerson Penal Code clearly mentioned the rape with her consent, with her will and with her consent, or without her consent. Both have the following circumstances. In finally, if the age of 15, it's clearly mentioned the rape, but 15 to 18. The men also affected the adult age of married couples.
The men also affected.
The presumption made by the court simply says the only golden principles of our Supreme Court.
It is a colonial legislation. It is a IPC is not applied not United Kingdom itself it was abolished. And why you stick on this provision in India?
Because it is not a neutral generality. Gender neutrality. This law is not the section of 375. This is not gender neutrality. So
was changing that when the physical was against the sexual substance. Now the thing is completely modified, completely changed. Accordingly, the law was very copy. The state is
the state has to follow the international guidelines.
I addressed in the question for the reference of Kerala High Court Justice Mohammed Munta question Ramchandra versus State of Kerala 2022. Section 375 is not a gender neutral provision. If it tricks a man under false promise of marriage, she can't be prosecuted, but a man can be prosecuted for same offense. What kind of law of this? It should be gender neutral. The Honorable Supreme Court.
How will you make a woman be labor?
The 375 only protect the age of 15. Age of 15, and apart from this, women are protected other laws.
Challenging marital rape exception or 375.
375 exception 2.
But you are arguing, you are asking, you are challenging this 375.
I will address in previous court decisions for my side.
Earlier you mentioned on Kerala court judgment that please not be gender biased. It is only favoring women, not men. That's why you are concerned as to how will you make both the gender liable under please not be biased. Now it is about the exception only. Kindly explain and how do you mean to say that is gender biased?
Sexual acts by a man with his wife, the wife not being under 15 years of age, is not rape.
Not 15, 18.
According
As per LPC, it is 15.
15.
As per the independent thought judgment, it is 18. So it is a harmonious construction the Supreme Court made in the independent thought judgment of India. So now it is 18, not 15.
Much obliged, Lordship. Section 375, 376 is non-gender neutral. Criminalizing marital rape exception will violate fundamental rights of men under Article 14 and 15, which not equally protecting the male as like it protecting woman only. Hence, criminalizing marital rape won't be constitutionally valid. Therefore, the council seeks permission to move on the prayer. Therefore, in the light of the facts stated, argument advanced, and authorities cited, it is most humbly prayed and implored before the Honorable Supreme Court of Imatta that it may be graciously pleased to adjust and declare the living relationship cannot be considered as a marriage and marital rape cannot be brought under the purview of living relationship. The implementation of election manifesto by the government is not constitutionally valid. The criminalization of marital rape is not constitutionally valid. Also passed any other orders that this honorable courts deems fit and proper in the interest of justice, equality, and good conscience. Much obliged, Your Lordship.
Council seeks to
Counsel, rebuttal will only pertain to what they argue now, not anything pertaining to memorial.
Yes, Your Lordship. Much obliged, Your Lordship. My learned counsel said that implementation of election manifesto is constitutionally not valid. So here they were speaking of men's right, that implementing election manifesto will affect the fundamental right. Here, actually, we are also contending the same thing. Implementation of election manifesto will actually eradicate the fundamental right of the women. Because speaking of men, their fundamental rights is not getting affected because the rights are not abridged. The fundamental rights of men are not abridged. Rather, they are just punished for the act that they're committing. So there is no fundamental right of men getting affected in a case of implementation of election manifesto. They're getting punished for the act that they are doing. The next one is they said that the main intention of marriage is not sexual intercourse, and there is also other things. The same thing is contended by the petitioner as well. The main intention of marriage is not just sexual intercourse, but also having conjugal rights. But when that sexual intercourse or other things is accompanied with force or threat or domination, that is where the problem lies. That is why we are pleading for all such kind of thing. Apart from that, we don't have any contention against the respondent. That's all, Your Lordship. Much obliged.
The council seeks permission to surrepart. Much obliged, Your Lordship. The learned opponent council stated that the marital rape, criminalizing the marital rape would create
Marital rape exception which is existing now, violating the article, violates the fundamental right of a woman. What we could to support that if the criminalization of marital rape happens, it will violate the article 14, article 21, the fundamental right of men. And we should again state that as with this section 375 and 376 not being gender neutral in nature, only men being punished for the offense
will violate their equal protection of law. That's all, Your Lordship.
Okay, the councils, the spectators can go to the first floor right review.